will not likely be built. There will be no point in building it. Development starts off State Highway 10 and Waitara Road, and there's nothing happening between those developments and Kerikeri. So by the time it gets to there and is in the CBD at the correct stage, things can change. So described before by the engineer as significant earthworks through perhaps site B, but if that was a very lightweight feature pedestrian and cycling bridge that might span above all that is much flatter grade than perhaps an original road bridge, that would be a lot more economical to build than putting the road connection through that other point, probably a lot more palatable for local people as well.
Okay, thank you. Look, no more questions. Thank you very much for your evidence and your attendance today.
Mr. Chair, we've been getting sparse on clarification questions today.
Yes, if you like.
Just wondering, and I apologise to the witness of in fact misinterpreted the point of the slide. There was a slide here that had the like a water body, and I was just really wanted to inquire whether that was representative of the representation of the 120 metre wide floodway.
Yeah.
So that was correct.
That's what I thought.
Representation.
Oh no, that's a representation of how it would typically look, and that might be maybe a 3 metre wide, very shallow, continuous running stream down the middle of it. The floodway would, my understanding, would overtop all the paths and everything in the green spaces each side of that.
Yeah. So I think that slides of structure plans for area and floodway. That's what I was interpreting it to be, as the floodway. Yeah. So what you're doing is you're showing a small channel which might be permanent or serious.
Yes, there all the time.
And then the rest of it is the 1 in 100 year floodway.
Yeah, the grass areas, and the water would rise up over the grass in a flood and then drop down.
Yes. Does that clarify?
I suppose, yes.
It was considered a desirable landscape feature to actually have a small continuously flowing stream in the middle of the floodway, as opposed to just a shallow dish that might have water down it sometimes, so actually making it possible.
I think Mr. Cooper clarified it might be and it might not be. That was something that might have to be determined whether it was a permanent stream or not.
I think with the weather in Auckland, it will depend on the time of year, but
I think when I heard his summary, he was saying there may be an option to take this ephemeral waterway and make it permanent as part of some upstream catchment management strategy. So it seems to me that you've taken a little bit of license and shown a permanent stream.
Yes, I understand. Yeah.
You're right. That was Mr. Cooper's evidence, was that there are options available to maintain flow, possibly not at this level of flow and this image at times, but to maintain floodways. It's not intended. It's an opportunity to provide significant energy. It's not intended to just be a brown, channel of dry mud for 90% of the year and only full of water when it's flooding.
Okay. Thank you.
Okay. Thank you very much.
So Connor, 8 minutes to 5, we've got 8 minutes.
Right. Do you want to do 5 startups? I'm sure it wants to make.
No, we'll take as much time as we need. Obviously, in planning evidence, we rely on your expert witnesses.
Yeah.
So we could probably take that as accepted. But obviously, you might want to touch on some matters that have been brought up in evidence and questioning.
Yes, Mr. Chair, I was wondering about whether or not I did that first, and I've got notes and things and go back and address things questions that have arisen based on our experts, but it's up to the panel. I'll address it however you like, and I've got some speaking notes and other things that have arisen. and then whether I either do it first or last. I was thinking maybe last, just go back to Mr. Wire's conclusions in the Section 42A report and just briefly go through. There's a very comprehensive shopping list, if you like, of deficiencies and things in there. So I think that.
How much time do you think you need?
As you know, I can talk like that, so
And actually, so much.
probably 15 minutes.
You've got 3 planners here on the panel, so
Yeah.
we all want to ask the same type of questions, so we're not all going to ask them. So we'll be keeping our questions reasonably targeted as well.
Okay. So let's take it like that then. I will just get to go for it. Backwards actually. So if we start just with Mr. Neil, that's fresh in our minds. From a planning perspective, the reason that I have suggested a comprehensive development plan is that all of these things are complex, and I think that's come out in the evidence stage. So we don't at this zoning stage work out how much water is going where, when, exactly what all the urban design principles will be, exactly what house is going where. So the purpose of that comprehensive development plan is it provides that opportunity to undertake the next layer of detailed assessments. So I'm confident that for purposes of rezoning, we have enough information and we know enough that the land can be rezoned. But as the panel is well aware, there's a subsequent stages of very detailed assessment that need to occur post-zoning. In my opinion, the best outcomes will be achieved by doing that next layer of detail across all the relevant technical disciplines and working out how all this works and working out staging and working out with the council the infrastructure that needs to be provided by whom and when. And then that segues into Mr. Eiler's comments about on-site wastewater treatment. Now, I have prepared the precinct provisions, and also, if it's necessary for the panel, I can provide. I also provide a cross-checking document where I've got this in the precinct, what's in the general residential zone, what's in the mixed-use zone that council's proposing, what's in our national environmental standards, freshwater management, soil contamination, etc. And of course, there's regional consents because it's not a unitary authority just yet. It sounds like it's coming, but not yet. So if there were to be a staged option of an on-site wastewater disposal system, as we are aware, that will require a discharge consent from North West Regional Council, possibly some sort of air discharge consent, depending on what sort of system it is. It's going to require regional consents. That's going to have to be designed with civil engineering, geotechnical advice, etc., as to where it can go. It's got to be clear of wetlands and watercourses and all of those things. It has to be worked out, and it would need to be addressed because it's part of the staging and infrastructure servicing requirements in the precinct. What happens when that's no longer required? What happens to the land post that, and in terms of remediation if things required or it's actual urban use. So how I think I've structured this, someone else may have a better idea, is that all of those things will be captured and can be considered.
And you don't need to be specific at this stage in the precinct provisions about that particular issue, wastewater treatment disposal.
There are provisions in there that you need to detail what infrastructure and where and who's paying.
Yeah.
What, where and when and who.
And that's sufficient in your mind.
Because based on the evidence of our experts, and these conversations have obviously been going on since about 2021 or something, like well before we prepared the submission and launched it. So for 5 years, I've always been satisfied there are solutions. There's a range of solutions, but I cannot sit here and tell you today what the best solution or the ultimate solution will be. I do expect it will be staged. Well, firstly, there's no way you can deliver all that development in one go. So there is going to be staging, but I also don't know exactly what the staging will be, whether it's going to be 200 houses, 400 houses, etc. But as I said, when I jumped into those legal submissions this morning, the staging detail needs to be worked out because resource consenting requires that detail. You can't these days just have some generic statement when you lodge a resource consent about it's going to be staged. As Mr. The Chair pointed out, you need to say this stage, this indicative time frame, this is its spatial land area, this many houses, and this is what the stage requires, and then your resource consent conditions say stage 1, etc. So that obviously, in order to get to that point, requires an awful lot of detail, and that detail needs to be worked out, in my opinion, through a comprehensive development plan process that will also work out how much water is going down that floodway, and also have hazard risk assessments as required by the district plan provisions that are already in there. Restricted discretionary activity, you need to demonstrate the risk is acceptable, evacuation routes, etc., etc., etc. So that's all got to be, and if you can't demonstrate those things, well.
So the way the CDP works, it's triggered by the first resource consent, and we're all familiar with how that mechanism works in other plans that we've seen it in. So if staging is to be addressed as part of that development plan process, would you then identify all the staging at that point, or would there be further development plan processes to determine other stages, and how would they be triggered?
My intention of how I've written this is I think you have a comprehensive development plan. You need to plan and work out all of those stages initially, because a lot rides on that in terms of.
Well, that's exactly where I was heading.
Yeah, absolutely. You need to work it all out. There's a note in the provision that says there may be multiple resource consents. So resource consent 1 and your comprehensive development plan for all of the stages, which might be over 10, 15, 20, however many years. And then there'll be subsequent resource consents. As we all know, things change over time, and we've all probably literally done hundreds, if not thousands, of Section 127 applications or further resource consents to assess things as things change over time. So I don't think there's anything unusual in that. Plan provisions sometimes get outdated and people lodge more non-compliant applications and they get granted because time's moved on and there's a different existing environment, etc. It's not. So say, well, good, but we're not that good that we can predict everything that's going to be or happen or in 20 years' time. So I think the point is that before anything kicks off, and that is the point of the comprehensive development plan, that the detail of what's needed and when it needs to happen is worked out and clearly locked down from there.
Do you think there needs to be, I noticed you've referred to staging in your assessment criteria. Well, sorry, your
there's a rule.
matters of discretion.
There's actually a rule in there.
Yeah, R5.
Yeah.
And I'm just wondering whether if we go down this path, whether it needs to, say, identify all the stages.
That's what I could easily do that, and I do accept, as I said this morning, these sorts of rules. We don't hear from everyone, and everything is discussed through the process. There's always tweaks that you can make. So I'm more than happy to look at those. I've written a few other notes as we've gone through today, and other things that could be wording to the provisions to make it clearer. One that was with respect to the comments to the mixed use zone, to detail the types of activities, like you would normally if you were doing a commercial resource consent for, say, a block of shops or something, you would normally say, I expect the activities will be X, Y, and Z, so you can assess car parking and things of that nature. And one other point there, just in terms of the questions of Mr. Neil as well, was that let's check back in the side yards in the general residential zone, which is the zone we're seeking, 1.2 metre yards all around except for the front yard, which is 3. So it is quite a compact, just in relation to your questions, Mr. Kensington, it's quite a compact set of development standards we've got in that zone. So I can't say that image was directly reflecting that, but I'm just aware of the newer parts of Warkworth where you've got quite large dwellings and quite relatively permissible, people can get the height in relation to boundary, and you have very large houses that are, well, 2.4 metres from each other.
What's the front yard setback?
3 metres.
3 metres as well.
Yes.
Okay.
So it is quite a compact, and there's a standard in there for of facade length and an outdoor living space requirement. So they're the standards that we are relying on, and I'm proposing to change those. Apart from this, obviously, identified area of large lot.
Yeah. Just while we're on it, maybe you could talk us through the policy number 10 that you proposed there, which talks about the ring section sizes, keeping with the underlying zone and precinct plan. I understand the underlying zone side of things. The precinct plan part of that policy, what does that kind of mean?
So my
Number 10.
objective 10.
Policy 10.
Policy 10, sorry.
Which I guess goes all the way back to the strategic objective about getting this mix of housing typologies in place and that sort of thing.
And my intention, my thinking when I drafted the CP again is that there's a landscape driver in there and urban design as well. So when you're taking that more detailed look at the land and layering up all your civil engineering factors and the floodway and everything, and the precinct plan was indicated that maybe some larger lot and your mixed use zoning things, that, well, in my experience, those things fall out of that more detailed and more difficult process.
So the reference to the precinct plan is in that policy? What does that mean?
In keeping with the underlying zone and the precinct plan, is because the precinct plan indicates things like the floodway, the SNA.
As in terms of the spatial
Yes.
arrangement. Right, okay.
Yeah.
Nothing to do with section sizes?
No,
Right,
because the
okay.
spatial plan doesn't delineate section sizes. We're relying on the underlying zoning for that.
Yeah. Okay.
Actually, that just flagged one more thing I did want to cover off too, which was in relation to ecological. And you didn't have any questions or anything, but it is important to note that we have identified SNA because we need to, well, we would anyway, on the present plan, but it's a requirement now of the National Policy Statement, Indigenous Biodiversity, the rural vegetation.
I think, Mr. Wyeth, we would probably relabel that area of significant Indigenous vegetation.
6, just because we've recommended that references to significant natural areas are removed from the PDP. So
Literally what's been recommended is that you don't refer to significant natural area, you talk about it as a significant Indigenous vegetation.
Okay.
So it mirrors section 6 rather than SNA. Is that correct, Mr. Wyeth?
correct.
Yeah.
And it's like indicative, so it's just allowing the potential for
Yeah.
area to be assessed as such.
I mean, and that's just really just get us through this NPS IB circumstance that we seem to find ourselves in.
So that's section 6 and yes, okay, that's good.
So while we're looking at policies, I asked Mr. Thompson about the risk of the commercial zone potentially undermining the viability of the Kerikeri-Waipapa, the sort of cutesy local villagey retail that you get primarily in Kerikeri supermarkets such as Briscoes. And function of Waipapa as the LFR, large format retail centre, which is wider than Kerikeri services right up to Kaitaia. I'm wondering, he said, look, the way I model it, it's not going to undermine either. I'm wondering, but you've got a policy in there that says deliver a range of commercial activities to provide local employment service to the neighbourhood community. I'm wondering whether that could sort of have something in it that sort of would say something like without undermining the commercial viability of Kerikeri or Waipapa, Waipapa or existing commercial areas. It's thinking about how you would make it become.
It's the continued vitality of Kerikeri Town Centre. So what were the...
I was just saying, without, you could add to it without undermining commercial viability of existing commercial areas. So something that's, again, we're just looking at ways this could be improved if we were to grant it. Okay, so.
Honest.
So where do you want to take us now?
I'm just thinking that there was no other questions in I think that's those. I did write some speaking notes, but I think we've covered off most of the matters and legal submission and the other experts. But if it's helpful, I could just go through it's paragraph 510 of the 42A report where Mr. Wyatt summarises the KO assessment. So if we deal with Mr. Thompson's evidence, I think it's pretty clear that some spatial plans, some greenfields is needed, and greenfield development can occur as an addition to infill and the PDPR and things. So I think that's covered off from my perspective. I don't hear anything there that in relation to the issues raised by council, in my professional opinion, they closed out. I think we've covered off the PDPR and the legal submissions and things, and that is also my professional view. The submission from KFO stands on its own merits, and we have highlighted various witnesses' issues with the PDPR. And I think that issue of, I just flagged this morning actually in relation to the term zone thing, that the council's own report raises an issue with infrastructure in the Fairway Drive area in relation to what being the reason why mixed use couldn't extend over that area. But then there's a medium recommendation in the PDPR for medium density zoning to go there as well. So I just said, I don't know what those infrastructure issues are, but if there's an infrastructure issue for the extension of mixed use zoning, then I would assume that potentially there's an infrastructure issue in relation to medium density zoning as well. The uncertainties, I think we've covered off ecology. There is really no uncertainty. Flood hazards, again, can be addressed. Infrastructure can be addressed. Transport, there are lots of options. Urban design, and I've put through how those things are interwoven into the comprehensive development plan. And there's a range of adverse design and transport effects. I covered those, and flood mitigation. The infrastructure, in my opinion, it's very clear in the CDP about infrastructure and infrastructure funding, and you cannot engage or enter into a development agreement to fund infrastructure until you know exactly what it is you need to deliver and the funding framework. So you cannot, at this point, when you don't even know whether the land's being zoned or not, enter into a developer agreement. So my client's made it very clear in his own evidence, and I have reflected those outcomes in the planning context through the CDP provisions, and I just do not think it's possible to be clearer or more secure than that at this point in the process. And it's completely normal in my experience that those things get dealt with in due course through the process. There's potentially new legislation coming on these infrastructure funding things. There's a range of mechanisms the council's got. It's stated in evidence that infrastructure will be planned, paid for, delivered. I think that's really closed out. And just in terms of the high level options, in my opinion, and Mr. Dozer was going through it legally with you earlier on today, this is the only submission we've got that is seeking greenfields development. At the time the submission was prepared, our opinion was that Far North was urban environment, but the council did not prepare the plan in that context. And now a decision has to be made that gives effect to the MPSUD in the context of Far North being a Tier 3 area, and you only had one submission. In my opinion, that really enables you to achieve those outcomes in terms of the MPSUD. I'm happy for you to ask me.
Sorry, is that it? I was looking.
Sorry, yes, I said I'm happy for you to ask me.
I was looking at G.
I was just writing down some of your comments.
I'm interested in your response to G. Is that because, I don't want to put words in your mouth, but what you said earlier about how the precinct relies on other underlying zone and other provisions of the plan to cover up that detail?
Yeah, so on the, obviously Mr. Wyeth is entitled to his professional opinion. I don't share that opinion. I do not think that precinct provisions do have a range of shortcomings, and it may be, and maybe it would have been more helpful if I had provided more detailed analysis of, as I took you through the national environmental standards, the regional plans, and the other provisions in the proposed district plan, and analyse how the precinct provisions fit with those. And as I said, I am happy to provide that analysis. It's helpful to the panel, to council, but my understanding in terms of the national planning standards is a precinct should be fitting within a plan. You're not rewriting every rule in the plan and bringing everything through into it. There's nothing in terms of our assessments that has indicated the need for, say, for example, different noise standards, or different lighting standards, or different natural hazards. That's why so we've tested all that, gone through a long process, and the precinct is an addition to, not a instead of. So I don't think it is sufficient, and if that is still the view of council officers, I'm willing to sit down with them and have a conversation about what's deficient and why. And as we all know, planning provisions can be rushed into processes.
So are you happy that you responded to all the points in paragraph 5.5p of Mr. White's Article 42A?
Yes, I am. Oh, sorry, that was just 5.10, did you say?
Yeah.
3. Yes, I think we've dealt with the economic side of it, and we've talked about the PDPR and the relevance of that. And the uncertainties have been discussed quite significantly in the course of the hearing today. And transport. I noticed Ms. Epsom, we have discussed the landscape issue, and we didn't call Mr. Farrow, but Ms. Epsom did raise an issue regarding the change in topography between Gulfview Road and the site. I think that will be explained for yourselves when you go up there tomorrow. Again, there's a range of alignments, and I have looked over the golf club and onto the site, behind the fence, etc. I am not an engineer, but there are a range of options, and I think some of those options seem to me to have reasonably gentle topography, particularly in terms of other areas that I've seen developed like Warkworth. So whilst I appreciate there may be some landscape issue or thing to be dealt with in terms of whatever road alignment is finally determined, or pedestrian connections, cycling connections, the CDP requires that landscape assessment done as part of that review at the time, and obviously again the effects are not acceptable of whatever alignment.
Yeah, so you heard a question I put to Mr. Brown. It seems to me that he thinks that pedestrian cycling is essential. But obviously you showed that updated plan which shows indicative, and we're trying to reconcile what you need pedestrian cycle connection. I think Mr. Brown was saying, well, I think indicative means I'm not sure where it goes. And I think he's interpreting indicative in that sense, as opposed to indicative as in whether it goes, whether it happens at all. But you would agree that it certainly needs to go in that locality and at the timing that Mr. Brown recommended?
The timing in terms of the transport trigger, let's call it, 1600, we actually reanalyse what you're doing. I agree there does need to be connections, but I labelled those indicative because there will be, yes, I agree there needs to be a connection back to Kerikeri, but as we've heard through the evidence, there's things that need to be resolved before that happens. If it were a council rezoning proposal, for example, council would then probably intend on doing some notices of requirement and things like that to designate roads. My clients do have other options that they are exploring. I'm quite confident there will be connections back to Kerikeri, and yes, they do have to happen in that time frame. I think those have to be dealt with in that staging. And
I think that would have to be dealt with as part of your comprehensive development plan, though, and it has to be confirmed as part of that.
correct.
The chances of things isolated island of development are quite high from what we do today, because of the uncertainty associated with the one that moves back to Kerikeri.
Well, I think I've heard today there's a pedestrian and cycling connection that's been explored by Quail Ridge coming over. There's the Turnstone land, which is ways of eventually connecting through there. So there's things happening in Kerikeri, and you're correct, Commissioner, the CDP does ask for those things to be locked down at stage. Not saying that that's part of the staging thing. They'll be locked down. That's not saying that it's all going to be delivered on day one. And as Mr. Brown said, might be, by 10 years you'd need to get those connections back. I think he said 10 years back to Kerikeri Town Centre.
Just rounding out where we started on this, all of this, some concerns. So are you saying that item 12 in the CDP matters to be addressed, landscape assessment, would cover off those roading kind of issues? So it sort of talks about urban development. Is that all encompassing of roading as well?
Well, I think you can't have urban development without the roads and all the other things. I use that terminology, and maybe we need different terminology, but yes, that landscape assessment in conjunction with the layout, location, type of lots, the proposed staging, how that aligns with the delivery of the required infrastructure, road connections and access points, including land required for the roundabout connection to State Highway 10, and then the internal roads, private access ways, pedestrian and cycle connections, funding, best investment, art reserves and open spaces and things like that.
Okay. Thank you.
Right. Okay, well, I think, thank you for summing that all up for us and answering our questions. I think we've got anything from council officer you'd like to clarify at this point?
Not with Mr. Connor, maybe with Mr. Duisberg.
Okay, well, happy to hear.
Yeah, look, I understand that there was an update to Mr. Brown's transport evidence. He did an update to that. I don't think we have that.
It's attached to Mr. Hughes' rebuttal evidence.
Okay, thank you. Thank you.
Right, no,
And some of the, just like, again, this is probably just one clarification again, that we saw Mr. Allen's evidence, some of the photos and his evidence, so get those as well, please. Mr. Neil, to listen. Mr. Allen, I was thinking Mr. Neil.
If you want Mr. Neil's, I wanted to see Mr. Neil's.
The complete set, please, that was used in this one.
Yeah, if we haven't seen that through, we'll make sure.
Yes. That's all. Great, thank you. Okay. Well, look, we've done really well today, everybody.
Can I just touch on one point? Sorry. And it's just a question from Commissioner Watson about infrastructure. You signalled that you might like me to touch on uncertainty regarding infrastructure. And look, as Ms. O'Connor has addressed, the provisions are designed to respond to that. In accordance with Minute 14, we contacted the council and we actually had a meeting or two and exchanged correspondence at the beginning of the year to try and pin down these infrastructure issues. And the core response we got to our inquiries about water and wastewater capacity and plan projects was that the bigger infrastructure report was the latest information that the council had. And that was consistent with minute 14, asked the council for its information about infrastructure. We did, and we were supplied with that bigger report, which is the report that supported the spatial plan, essentially. And so, based on that report, Mr. Evans produced his evidence, and it was then based on that evidence, the response was the infrastructure solutions are feasible. And so, we have sought to engage to the extent that we have, well, we've sought to engage with the council, and with the material that we provided, we've done the best that we can. The Becker report is a high-level assessment of the potential capacity of the existing infrastructure and the planned upgrades that would be produced. But in the absence of having the council's future work program that has apparently been provided to this forthcoming CCO, we just haven't been provided with the information to provide more detail. We would love to, but Mr. Ehlers is working with what he's working with, and my submission is he's delivered something that's feasible, and he's done the best he can. He has.
Okay, thanks, sir. Thanks for following this around.
So I suppose I should ask the question, does that conclude your case? Okay, but thank you very much. We've got through a lot of evidence today and you've paced it nicely. I think we should adjourn now. And as I say, we've arranged to go, we definitely will be going out there Thursday. It looks like we're going to go fly about it first, and then we might drive back to have a look at specific things following that, and we might see everything we need from the year. But we are going to go have a look at another site, including Turnstone, and just in the locality. We're going to go visit another site for you, and then we'll have the afternoon as long as we can. First, thanks again.
Oh, sorry, Mr. Chair, one thing that might be worth discussing is who's going to guide you on that trip. We'll need someone who's familiar with the site entirely, but preferably not someone who's giving evidence to you, was too involved in this case.
I think we could rein in. I think it was the real estate. Your
proposal is the reality is there are two or three people that could do that, and it's Mr. Brownlee or Mr. Corbett, essentially.
So we're happy with Mr. Corbett, and
I'll give you.
You'll give us an instruction. And we don't have to wait someone who tries to get through the evidence.
If we had our administrator as part of the site visit, that would provide some.
Oh, she is.
Yeah, I mean.
I trust everyone involved.
You end up giving us evidence, Mr. Corbett. AK will rein you in.
But my experience with administration people on those sort of site visits are very effective.
It's not something I'm overly concerned about. It's just worth raising.
You make that. We've had a number of submissions of scorchers around their properties, and they've understood what their role is. It's just to point out things and not to deliver evidence. So, thank you for reminding us. So, look, I think we're going to be adjourned until, we will be adjourned until 9 o'clock tomorrow. Thanks again, everyone.
I'll just close us with a karakia. Turuki whakataha, whakaire te wānanga, kia wātia, ai rā, kua wātia, huie, tākie.
Here, I will